floor speech at 4 p.m., so I'm going to let him do his questions. I'm going to vote. I'll be right back.
Thank you, Mr. Chairman. And I will say, Ms. Brennan Crone, I very much hope that senators are not expected to count backwards from 100 by sevens. I was told there'd be no math in this hearing, Mr. Chairman, and I'm really concerned that you've changed the rules on us.
I share that hope.
And the Senate would be a much smaller body if that were a test required for continued membership in it. Thank you to each of you for your participation in this hearing. Thank you for addressing these important questions. As I listen to these policy issues, I'm reminded of 22 years ago, in 1999, I was a young policy staffer on the George W. Bush campaign when he ran for president. And it's where I met my wife, Heidi, and one of the policy responsibilities I had was focusing on disability issues. And I worked with then Governor Bush. I worked with a number of disability rights advocates in designing what became one of President Bush's first initiatives, the New Freedom Initiative, which we hammered out on a laptop with bullet points, and it ultimately got enacted into law. And the guiding principle was that individuals with disability, like everybody else, want to be free, want the maximum autonomy possible, want the maximum independence possible. Not every person is capable of total autonomy depending on their circumstances and their physical condition. But to the extent possible, everyone deserves to have the right to control their own life, whether we agree or disagree with the decisions that person might make. And I think this discussion, all of the witnesses powerfully highlighted that. I'd like to start my questioning, Mr. Klaus, with you. I want to thank you for being here. This can be a daunting place, and telling your story, I'm sure, is not easy. But I want to thank you for your courage, because right now there are people at home watching this on television who may, like you, have faced a traumatic brain injury or some other accident where they're struggling with the repercussions of it. And there may be people in conservatorships who themselves are wanting to be free of those constraints. And your courage, I believe, is inspiring people at home right now. And so I appreciate that. I have to say, sitting and listening to you and hearing your story, you're a grown man. You're gainfully employed. You've had a series of impressive and difficult jobs. You're a husband, you're a father, and yet you lacked, for a significant period of time, the legal right to make decisions in your own life. And I think for a lot of people, that's an astonishing state of affairs. Could you share with this committee, while you were under the guardianship, what kind of decisions and activities were you not allowed to make on your own? And how has life been different after it was terminated?
Well, first off, I talked about my financial. I wasn't allowed to make financial decisions or medical decisions. I wasn't allowed to decide who I was allowed to hang out with or where I was allowed to go. I was pretty much treated as a child in every aspect, even down to what phone plan I could be on if I wanted to, if I had a phone. But since then, I mean, it's life-changing. First thing I did was I was able to go fill up my tank of gas and not have to worry about my car getting declined even before swiping it. And I haven't done anything irresponsible or anything since I had the guardianship terminated, but I'm just living like a normal adult, and I'm finally watching my hard-earned paychecks come in. And it's It actually feels amazing. I lost that sense of worthlessness when August 24th hit.
Well, thank you for sharing that. As someone who Heidi and I just celebrated our 20th anniversary, and I will say, if what you said is right, that you haven't done anything irresponsible, you may be the only husband on planet Earth who can make that claim. I certainly would not be so bold as to say such a thing. Ms. Whitlock, we've heard about the constraints that Mr. Klaus faced. We have also heard about the constraints that Britney Spears is facing. In your experience, how unusual are these constraints for people facing conservatorships, and how does Mr. Klaus's story or Britney Spears' story compare with the other clients you work with?
I wish I could say they're uncommon stories. They're not uncommon stories. I've been practicing in this area for around 20 years, and I've seen many people in the same kind of situations, having their health controlled or psychological, not having control over their psychiatric treatment, not having control over their money, not having access to a cell phone, not even their own, ID, not even being able to travel. All of these other kinds of issues are very common, and they affect people with all kinds of disabilities, all ages. And so I wish I could say that these were outliers in some way, but they're not. Unfortunately, guardianship can be very restrictive, and there's not the same kind of court oversight that people think there's going to be in a guardianship. Like, you think you go to court, you think you're going to have a court that's going to be overseeing this. It's very uneven kind of court oversight. And so unfortunately, I hear a lot of stories like this.
Thank you. Ms. Brennan Crone, Ms. Whitlock just talked about the lack of court oversight. You also talked about the lack of due process protections. In your judgment, what due process protections are lacking, and how can they be improved?
In a lot of cases, they're almost all lacking. There's really, the whole way down the line, guardianships are launched and implemented and imposed as though they're very routine, sort of pro forma circumstances, which they're really not. And it varies state by state, the precise process, but if you start at the base of, notice in some states can be by mail. It could be by mail to the address where your future guardian is also living. And even if you get the mail, it's a legalese document. You check this box, which means that this other thing has happened, and then that box is checked. People don't meaningfully understand what is going to happen, and often the people seeking the guardianship don't either, take even one step before notice, that people start this process thinking that it's just what they have to do because that's what a school told them, or that's what a family member told them, that's what they'd heard. And then hearings themselves are often, they can be seconds long, these hearings. You might not be at the hearing. Your voice might not be heard. There might be no opportunity for you to say, hey, I don't want this, or I don't like this, or I don't understand what's happening here.
And let me ask both Ms. Brennan Crone and Ms. Whitlock. I talked about the facts in Britney Spears' case that she was denied a lawyer initially based on a medical report that she wasn't allowed to see and the lawyer wasn't allowed to see. How common or uncommon is something like that?
Do you want to go?
No, I would say that I have seen that kind of circumstance before, where it's difficult for the person is not given access to medical evidence that's being used against them. I can't say how common it is, but I have experienced that within my career. And I think what it takes is really, really zealous advocacy. But in circumstances like you're describing, that kind of zealous advocacy of express wishes to be able to challenge the evidence that's being used against you did not appear to be present. And I think it really highlights the fact that there's a deep importance in having access to attorneys of your choice, and attorneys that are advocating for your express wishes, because that's another big issue that I see, where attorneys are advocating perhaps for what they believe is in the person's best interest, or these systems can be very insular. And, there can very insular systems that aren't really based upon a kind of civil rights focus. And so those can also be challenges when it comes to guardianship proceedings.
Now, Dr. Kripke, you spoke some about alternatives to conservatorship. Can you describe the efficacy of some of the alternative mechanisms to deal with someone with diminished capacity?
Yes, so we work as a team to deliver healthcare. Healthcare for people with developmental disabilities is interdisciplinary, team-based care, and it includes not just the healthcare providers, but the people who provide direct support to the patients, whether that means personal assistants in their lives, day program staff, job coaches. Everyone who's in their life has a part in recognizing when someone is ill, alerting a doctor when there's a problem, and in supporting that person to make the right decision for them, and then in carrying out the plan. So we work together as a team to make healthcare happen. And when you have a conservator, it's only one person, and that one person may or may not be a part of the day-to-day life of the person we're talking about, and they may make decisions that the team as a whole doesn't feel that they can implement and doesn't feel bought into along with the patient. So we work together collaboratively and work towards consensus instead of putting decision making in a single person's hands.
Okay. Mr. Slayton, you were able to participate in the process in Texas to identify the need for state guardianship reform and to oversee its implementation. Can you walk us through some of these state law reforms and how they help create greater due process protections?
Sure, Senator. I think one of the things that we started doing was just having a conversation with people under guardianship advocates, and really begin identifying some. And I think, as has been noted here, one of the keys is, changing from maybe what's been described as a pro forma system to full guardianship is the last alternative that's explored. So one of the things Texas law now requires is that every individual that's filing for guardianship, every attorney involved, all the judges must consider all alternatives to guardianship, all supports and services that could be offered, and then the judge has to find by clear and convincing evidence that there are no other alternatives to a guardianship. So it's obviously a high burden of proof to get there. And then one of the things I was thinking about with Mr. Klaus's situation, one of the things we did in Texas was it is often that someone with a traumatic brain injury or someone that has a stroke oftentimes get placed under guardianships, but their conditions improve. And so one of the requirements under Texas law is that when the doctor is doing the evaluation for a guardianship, they have to state in their report what the likelihood of improvement is and what time frame that's expected. And the judge is required to reevaluate the need for the continuing guardianship in that time frame and continuously doing stuff. So it puts in place these due process protections to where this is continuously occurring. And the last thing I would say, there's a whole series of reforms that we could go through here and spend some time, and I've submitted that with my written testimony. But another big one is really this idea of making sure that family members and friends are adequately informed about what their responsibility is and isn't. What we have found, as is noted in someone's previous testimony, that the majority of the issues come up when it's a family member or friend guardian who, let's just give them the benefit of the doubt. Maybe they don't know what their responsibilities are, what the limits are, and what other options they have, for instance, support decision-making or other types of alternatives. So making sure they're aware of those situations before they're in a guardianship is really important. And I guess I would just say that I said last thing, but one more last thing is this idea of the Bill of Rights. It was a really important development in Texas to really put in writing, these are a person under guardianship's rights, and that must be provided to them. And every year, in conjunction with the report given to the court, the person under guardianship has to be provided with their Bill of Rights again, and so that they understand they have the right to go petition the court to have the guardianship terminated. And I think those are all things that have been really important and I think have made a difference in our state.
So that's helpful. Let me, if I could, Mr. Slayton, ask you a hypothetical,
Sure.
which is Britney Spears' conservatorship is under California law, but given the reforms in Texas, had a similar fact pattern arisen with those reforms, how do you think the case might have proceeded differently?
I think first of all, let's just pretend that the reforms were in place before the guardianship was established. I think there would have been a pretty significant mountain to climb about whether or not there weren't other alternatives that would have been more appropriate, or maybe there could have been limitations in the guardianship. Could there have been supports and services put in place that would have satisfied the concerns of the court or the medical professionals looking at her situation? So I think one thing is right off the bat, the question would be whether or not the guardianship would have ever been established in the first place. I think the second thing is that there would have been, under these reforms, a more natural review of the need to continue the guardianship. I think there's been difficulty in getting that looked at, and in Texas, I think under these reforms, it would have been a natural approach, and the judge would have to again find by clear and convincing evidence that the need for the guardianship continues, and that there are no less restrictive alternatives that would be more appropriate.
Okay, that is very helpful. The time is expiring on the vote on the floor, and actually Chairman Blumenthal is back, so I'm going to run and vote and hand the gavel back to the chairman, but I want to thank each of the witnesses for your testimony, particularly you, Mr. Klaus. Your story is powerful, and to your wife, thank you for being here as well.